As the court is aware, there's
Objection, it was again not properly set for hearing because the order was sent through ex parte communications, and I have again not been provided a copy of the order from the courts to this date.
All right, let's go ahead and get started. Ms. Leva, you have your 5 motions to strike.
Yes, ma'am, and I just want to confirm really quick that it's showing. Oh, it is showing up. Thank you. I appreciate you letting me start. First of all, I want to make sure everyone did receive a copy of the amended filing. Ms. Borum had mentioned in one of her motions that she didn't like how they were 5 separate. They were not intended to be. And I just want to apologize to the court for that. I am not an attorney, cannot afford an attorney, nor can I find an attorney. And all of those motions to strike should have been in one motion. So for the benefit of Ms. Borum, I did amend it, put together as one motion, and instead of the affidavit, I also attached exhibits.
Ms. Leva, I'm going to ask you to slow down for me so we can get you accurate on the record.
Oh, yes, sir.
Okay, go ahead.
I also submitted exhibits for the courts as well as Ms. Borum. Every exhibit is a court document, and almost everyone has been ratified by a judge, so there is no danger of hearsay or anything else of the like.
All right, let me get your amended motion. I don't have your amended motion in front of me. Let me get it just a minute, please.
Yes, ma'am.
Solace, would you get that off the printer for me, please? Yeah.
And Your Honor, I don't believe I received any exhibits.
Your Honor, the exhibits were attached to the motion when they were submitted to the courts. They were accepted by the courts, and I even clicked on them and verified that they were correctly attached and were made available to Ms. Borum. Or we could use my affidavit instead, whatever you would prefer, Ms. Borum.
I have filed what looks like Exhibit A, and it includes.
Yeah, if you go down, it has all the exhibits attached to the file. And again, they've been on court record since, most of them since 2015, and a couple of them since 2018. 2 of the exhibits are filings that Ms. Borum, not Ms. Borum, but Ms. Newell submitted herself. And so the party should already have full knowledge considering they wrote it and submitted it. There's nothing new in the exhibits. They're all available on our case files.
All right. Go ahead, Ms. Leva.
Thank you, ma'am. So we're here today to discuss the motion for enforcement, which was filed August 21st, 2018. It was motion for enforcement of possession or access in order to appear and maintain 2 violations. And the other we'll start with that one, and contain 2 violations. Neither of these violations were a violation of my irrevocable mediated settlement, and neither one should have even been able to be submitted and accepted. I want to start with Exhibit 1 on page 1. It clearly states the mediated settlement agreement is not revocable. And we have Nicholas Leva and Sarah Leva's signature on November 11th, 2015. Above it states the parties understand and agree that this agreement is binding on all parties and not subject to revocation, as set out in 6.602 and 15.3.0071D of Texas Family Code and Civil Practice and Remedies Code, Texas Property Code, and other applicable statutes.
I'm
sorry, I thought I was speaking slowly, sir. I was trying to read slowly.
Okay, well, I want to try to get you down accurate here. So
I appreciate. I'll go even slower, sir. I apologize.
That's okay. I'm just trying to get you down accurate.
Okay, I'm trying to respect everyone's time as well. Apologize. Okay, as I said, it goes by those Texas codes and other applicable statutes. It is underlined as well as in all capital letters that each party specifically stipulates and agrees that she has entered into this agreement freely and voluntarily. This agreement is not subject to revocation and is enforceable as a contract. And then If you switch to the next page, technically it is the 4th page in the file. It shows on January 29, 2016, the court heard the case, and at the very end, it is signed and ratified by a judge on that day. Now, if we go, so I just wanted to clearly show that. Now, if we go to motion for enforcement, which was the very first thing that was filed, it was filed on August 21st, 2018. I also want to point out that it was also signed by Matthew Reek, judge presiding, on the exact same day, August 22nd, 2018. I had no chance to respond. I was given no copies. They simply signed enforcement without any evidentiary basis. On the page 4 of this exhibit, it states violation 1. On April 22nd, 2016, Sarah E. Leva removed the children from Birdsville ISD and changed the primary residence.
Slow down.
Oh, sorry. On April 22nd, 2016, Sarah E. Leva removed the children from Birdsville ISD and changed the primary residence of the children by moving to the state of Virginia. If you go, and again, I also went ahead and on all my exhibits, I put points of reference so that everyone could prepare before this hearing, just to make it easier. So if you go to the geographical area for primary residence on our mediated settlement, I believe it is on page 8. These orders are so big. All right, it clearly states, it is further ordered that the geographic restriction on the residence of the children shall be lifted if at any time Sarah E. Leva wishes to remove the children from Birdsville ISD for the purpose of changing the primary residence of the children. And this was intentionally included in our mediated settlement because we had lived in Texas for less than 6 months when Nicholas filed for divorce. The children were born in Virginia, their schools were in Virginia, their family was in Virginia. And so this was part of our agreement, as well as Nicholas being able to hide all of his finances, as well as his military benefits. I just want you to understand what he was getting out of this. I was able to go home.
The relevance of this testimony as it predates the last order in this case. And
Your Honor, that order again is void. There is, and if you would let me finish, Ms. Borum, you have absolutely no specific facts in which to add, nor is what you're saying is lawful. Any order that is built on fraud is void.
Your Honor, I'd like to renew my objection to this line of testimony as predating the last order.
When was the last order, Ms. Borum?
I believe that there was a trial held in front of Judge Catterton, a modification of custody on February 22nd of 19. That order was signed by the court on March 29th of 19.
Again, it was procured in fraud.
And then the controlling order was a order for supervised access through family court services. And that was signed by Judge Navarez on January 30th of 2020.
All right, I'll have to sustain the objection, Ms. Leva. Please bring your argument up to the relevant time periods, please.
Okay, so I want to just make sure I understand. So you are going to not allow me to move forward on my motion. You understand there is explicit and extrinsic and intrinsic fraud in the procurement of this new order, which makes it void. And additionally, you understand that we had an irrevocable mediated settlement, which Nicholas signed of his own volition, which he has breached on multiple occasions. But again, you are choosing to obtain her objection and be completely biased and ignore the letter of the law. The letter of the law states any order maintained through fraud, third-degree perjury. And if you let me continue, I can show how this is third-degree perjury, but I don't think Ms. Warren wants me to show that right now.
Your Honor, I would also that it seems facts not in evidence, as there's been no testimony put forward or elements met for the claim of fraud.
Objection, no testimony is needed. Again, it's all in the court records. The evidence of perjury is clear. One perjurous statement is more than enough to vacate the final order, which has already been proven in the last 5 minutes.
All right, overruled. Ms. Borum, your objection is sustained. Ms. Leyva, go ahead and bring your arguments up to the relevant time period, which would be from February 22nd, 2019 to the present, please.
Your Honor, again, that is against federal law, against Texas statutes, against my constitutional rights, intentional breach of contract, intentional breach of parental rights. I have done absolutely nothing wrong. I've been upward and honest. I have never broken our mediated settlement. Nicholas Leyva, Borum, and Newell committed third-degree perjury, and right now you are committing misprision of felony. So if we are not going to move forward on this motion, and everyone is in agreement that they want to basically ignore my basic human rights, as well as my children's basic human rights, as well as the Constitution of the United States and Texas statutes, we may as well move forward with Ms. Borum's.
All right, if you do not want to pursue.
Oh, Your Honor, I do. As I stated, there is fraud in procurement of a final order where they committed third-degree perjury. However, you refuse to let me move forward because the new order is void.
All right. You do not want to pursue your motion to strike?
I absolutely do. Okay, fine. We'll stick with strike and we will ignore the void. So, as I stated, that first violation needs to be struck because it is in direct violation of our mediated settlement. So she, again, committed third-degree perjury on a motion. And then we have the second violation. On July 1st, 2016, Sarah E. Leyva failed to surrender minor children to Nicholas Leyva at her residence. Again, third-degree perjury or at least intentional deception in accordance with our mediated settlement. Next time began at June 15th, 2000. June 15th for residents that were more than 100 miles apart. Not only did he not show up, he didn't contact me, but I cannot provide witness testimony. So we will stick with that. The truth is it is not a violation because he was supposed to be there on June 15th to pick them up. And he did not do so.
All right, response, Ms. Borum.
Yes, Your Honor. Once again, would object to the testimony based on the fact that it predates the trial that was held on February 22nd, 2019, which modified not only the MSA, but the underlying agreed final decree of divorce, which reflected the MSA. I would be happy to take testimony on this matter. However, to simply short circuit to my arguments, I would ask that the relief requested by Ms. Leyva's motion to strike be denied and that they be deemed as frivolous pleadings. As the court is of course aware, special exceptions and motions to strike, which I assume is what she is requesting today, should be filed with an answer shortly thereafter in a case and in a non-jury trial, which, excuse me, which was what was heard in front of Judge Catterton on February 22nd of 2019. These motions must be brought before the judgment is signed. That judgment was signed on March 29th, 2019. Under the Texas Rules of Civil Procedure number 90, defects in pleadings which are not brought before the judgment is signed shall be deemed as being waived. However, Ms. Leyva brought these motions almost 2 years after the fact. Her testimony has circled around actually actions that took place as early as 2016, and in her motion specifically, she objects to actions that took place in 2018, and this was significantly before the final trial that was held before Judge Catterton, in which testimony was taken and a final judgment was entered once again on March 29th of 2019. And so for those reasons, while I'd be happy to take testimony from Ms. Leyva, I would ask that her 5 motions, or rather the amended motion that was filed yesterday, be denied and that attorney's fees be awarded.
All right, Mr. Passmore, do you have any argument on this?
No, Your Honor.
All right. Anything further, Ms. Leyva?
Absolutely. First of all, what she says is untrue and insufficient. by law, anytime fraud is found, there is absolutely no statutory limit to fraud. There's no statutory limit to third-degree perjury. Additionally, at that time that she is speaking, I had two attorneys. One attorney removed himself from the case after the jurisdiction hearing, which again was blatantly biased, which I do provide records of. And I also hired Lindsay Newell after the final order, and I had requested her to adjust the perjury. However, instead, she canceled my appeal and took wage for disservice. I found out later that she had gone to college with Miss Lindsay Newell, and they were personal friends and operated together in order to have my children removed. I, however, will move forward without any further testimony. I will stick straight with the facts as well as the paperwork, just because testimony is unnecessary. So as I just previously stated, and we went over, motion for enforcement of possession or access of order, both violations were intentional third-degree perjury and need to be struck from the record because they hold no bearing or merit in regards to our mediated settlement. The second one that she filed was petition to modify parent-child relationship, which she also filed on August, which she actually filed on August 22nd. And this is also another issue. Oh no, August 21st. So she filed motion for enforcement and petition to modify parent-child relationship also on August 21st of 2018, despite our mediated settlements. And again, this was ratified by a judge in the same day without any reference to our mediated settlement, the law, or any evidence. So she stated in the modification that I removed the children from the state of Texas, and that was a violation of our mediated settlement. However, in her request to change parent-child relationship in the modification of prior order, she requested that the order include, on page 3 of 6, include a geographic restriction because there was none. She requested geographic restriction of Tarrant County, Texas, and counties contiguous to Tarrant County, Texas.
Your Honor, may I?
You may.
Thank you, Your Honor. First and foremost, I would object to the continued testimony with allegations of perjury and fraud, not to mention child trafficking, not to mention the allegations that the court and the attorneys in this case are involved in a cartel. There has not been any admissible evidence presented to support these claims, on top of which I would renew my argument that all of the issues that are being complained of by Ms. Leyva today predated the last order. She is in fact correct that a mediated settlement agreement was signed in that it was reduced to an agreed final decree of divorce on January 29th of 2016. That order was not revoked. In fact, it was properly modified by the modification trial that was heard by Judge Catterton on February 22nd of 2019. As of course the court knows, then that became the controlling order. Within that order, Judge Catterton granted my client the exclusive right to determine the primary residence of the children within Tarrant County. Shortly after that trial, Ms. Leyva exercised her first period of possession of the children. And during that period of possession, I suppose she determined that she would not return the children, which she did not, for 10 months. My client filed a subsequent enforcement, which is not being addressed by Ms. Leyva today, and which I believe we are still attempting to serve her with, which we were talking about at the last hearing, which I will happily address during the presentation of my motions.
All right.
However, also the allegations that the children have been kidnapped and she's been denied any access to them is also not supported by any evidence. In fact, the order signed by Judge Navarez did grant her visitation. She simply has not exercised it. I believe these motions were filed frivolously with the intent to harass my client, who's had to spend an inordinate amount of money to defend these hundreds of pages of motions that have been filed by Ms. Leyva. So once again, just in relation to the motions filed by Ms. Leyva and not the motions filed by myself, I would ask that the court deny them on the basis that they violate Rule 90 of the Texas Rules of Civil Procedure, and she has waived her right to.
Objection, Your Honor. Can Ms. Borum go over this when we are ready to address those issues? She has repeated these same things twice in a row now instead of just simply objecting. She needs to object as I present, not be a witness.
All right, I think I've heard enough on these motions.
Your Honor, this is inappropriate. For one thing, she just lied again. She said I had them after the final order, which I did because they never left the state of Virginia. However, I did not abscond with them. And that order was also fraudulent. Catterton stated that he thinks that we need to change custody without any statute or regulation backing it. He simply said that we had struggled with communication and that he hoped that by changing the jurisdiction and residency of my children and giving Nicholas Leyva making him custodian, again, without finding any fault with me or giving any statute backing his decision, said, I mean, this is how he put it. He said, I think, Nick, yeah, I better give Nicholas full custody in order to promote better communication. Since then, I have had no updates, no phone calls, no pictures, no response from Nicholas Leyva at all. I haven't even been able to verify
Motion to strike.
No, but I would like to continue with my motions to strike, ma'am. All right, so as we all know, the motion for enforcement, again, there were two perjurious violations that were never violations, which is against my constitutional rights. Petition to modify child-parent relationship supports this because she requests that the prior order be modified to include geographic restriction of Tarrant County, even though she claims it was a restriction already in her original filing.
Your Honor, as multiple motions of course have been filed,
Ms. Borum.
I ask that Ms. Leyva specifically identify the dates of the filings that she's referring to.
All right, Ms. Morton.
Absolutely. I actually started with that because that's part of the problem of why it's so fishy. The motion for enforcement was filed 08/21/2018 and then was signed by Judge Matthew Reek on the exact same day. And then again, petition to modify parent-child relationship was also filed on August 21st, 2018. Again, without any chance to respond, without having any copies. And in my opinion, this exemplifies vexatious litigation to the extreme. Additionally, an intentionally trying to defraud the courts, because they defraud the courts. They have built an entire case on defrauding the courts, and not a single one of any of their documents have ever had specific facts or evidence to back any of their claims. And I do want you to consider my prayer. Now that you are aware that they committed perjury, deceived the courts, defrauded the courts, and have continued to keep my children under a fraudulent final order that didn't even have any sufficient validity to back the order. As of today's date, Joshua and Samuel Leyva, who were Virginia state residents, have been held hostage for 492 days. They have been prevented from all contact with myself. I am their natural biological mother, their lawful custodian. The level of legal abuse, torture, intentional deprivation of children's rights, intentional deprivation of parental rights, third-degree perjury, financial fraud, not to mention breach of contract, shows a planned, decisive, and intentional infliction of torture inflicted upon Sarah Leyva and her Virginia state minor children, Joshua and Samuel Leyva. I also request all reference statements and admissions to be struck from the record that have been proven to be falsified. And I do request, now that the courts are fully aware of fraud and procurement, that there be at least an emergency order to remove the children from Nicholas Leyva's home and for them to be returned to me. I am okay without the money, even though it has been stolen from me. And I have had to pay a significant amount of money, not to mention lost extreme amounts of job income, travel costs, garnished child support payments from wages and IRS tax fraud. And not to mention all the missed child support payments, which again, I am more than happy to weigh. I simply request that my children be removed immediately from Nicholas in light of the fraud in procurement of final order, and everything else I'm happy to let go of.
All right. Any further response to this forum?
No, I would simply renew my previous arguments, and I would also point out that Ms. Leiva's continued allegation simply that she says there was fraud or fraud in the procurement without producing any evidence to support that, and also without having those motions before the court today. I would submit that
Objection. I would like to know how I have not proved fraud. I have just presented two incredibly important pieces of evidence that are on court record that do show third-degree perjury and fraud upon the courts. And no matter what Ms. Boram's saying, she can't change a lie into a fact.
All right.
Just because you state it does not make it true. There was fraud in procurement, and I have been victimized over and over and over. My children have been erased from their mother intentionally to inflict torture, which is established as psychological, mental, or physical pain, which, believe me, after 495 days, you state you have a 9-year-old, you would understand. This is insane.
All right, Ms. Leiva, please let Ms. Boram finish her argument. Thank you.
Thank you, Your Honor. So in addition to renewing my previous arguments as my statutory basis as to why the relief should be denied in this case, I would also like to reiterate that there hasn't been any evidence submitted other than Ms. Leiva's personal testimony that she believes that, based on her interpretation of the law, that fraud has been committed. However, as I've said, the mediated settlement agreement and the attendant decree were properly modified before Judge Catterton and entered by the court on March 29th of 2019. And so, once again, I would ask that these motions be denied and that attorney's fees be awarded as to her motions specifically. Thank you.
All right.
Objection to attorney fees. I've already filed as an indigent. I do not have any money. And again, as I stated before, they clearly committed fraud in procurement of the order. Regardless of whether, it doesn't matter if you acknowledge that or not, it's just truth. And I am simply attempting to see my children. These are not meant to harass or harm Nicholas in any way, which is why I was so willing just to remove all the other requirements. I don't want any money back. I do not want to hurt him in any way. I simply want our mediated settlement to be held up, and I would like to hold my children again.
All right, Mr. Boram, did you want to put on testimony of attorney's fees?
Yes, Your Honor, I would please. Would you like me to do as to her motions first and then to my motions and my presentation?
Yes, first.
All right.
All right.
My name is Catherine Boram, State Bar number 2404.
Raise your right hand.
Sorry.
Do you swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, thank you.
Thank you. Your Honor, my name is Catherine Boram, and my State Bar number...
Excuse me, have we finished with mine? Because I'd like to give a closing statement.
We finished with your presentation. She's putting on her attorney's fees as in response to your
well, I have one more thing that does need to be specified on court record before we move on to hers. I also wanted to point out the petitioner's supporting affidavit, which was attached to the petition to modify. This is not, again, a legal document. On page 2 of 2, as you can see, it is not notarized in any way, shape, or form. Actually, when I looked up the name of this notary, I found that she was social media friends with Nicholas Leiva. I don't know if she assisted him or if he just borrowed her stamp. It doesn't matter. I'm not going to try to imagine how it happened. I simply want to state that it is not a notarized affidavit and it is not a legal document to back the petition to modify child support either.
Anything further, Ms. Leiva?
No, ma'am, go ahead and have her start. Excuse me, ma'am, are you going to give a ruling on my motions before we hear Ms. Boram's, considering mine were put forth in January and do contain, again, extensive extrinsic and intrinsic fraud, which I just showed to the court today. Should there be a ruling on that?
I'm trying to get to that part where I can rule, but first I have to hear from Ms. Boram. All right,
even though her motion was, Your Honor, I want to speak on her motion before she moves forward. I have some.
No, we're not there yet. Excuse
It
me.
is a
we're not there
procedural
yet.
question, ma'am. It is a procedural question. It has nothing to do with her actual filing. In her filing, she filed it Friday at 3:30 p.m. And again, this is what makes it vexatious. She filed it at 3:30 p.m. on a Friday. It was accepted and served by the courts at 4:59 p.m. at the time of closing of the courts. And then somehow Kate Daniels sent me a copy of the order for hearing about 5:30, and I have never received an order of hearing from the courts. And I would like to know procedurally, Ms. Judith Wells, how you were able to read a 7-page motion, order a hearing for it, all within 20 to 30 minutes after the courts were closed. Additionally, I would like to point out that a copy of this order was never provided to me. So I don't know how, again, I mean, was this order already signed and just waiting for her to file the motion? Was it just signed because the motion was unread? There's just not enough time for this to have occurred, and it's completely inappropriate that it occurred after closing on Friday on a holiday weekend and had an order before I had any opportunity in order to respond to it and stop a hearing. This is a frivolous filing in direct relation to try to stop the truth and the evidence from coming out about fraud in procurement. Additionally, I did go over her entire filing with someone who's been a lawyer for over 40 years, and there's literally nothing specific in it. She makes very general arguments. She does not provide any evidence. She does not provide any specific examples. And I wanted to bring that to the attention before she tries to make specific examples without providing, again, any opportunity to respond before order or any opportunity to review it before litigating against her in a court of law, which is my right. I have a right to know what her arguments are going to be before they are made.
Your Honor.
Yes, ma'am.
First and foremost, that my motion for special exceptions, motion to compel and for sanctions, and motion requesting that Ms. Leyva be deemed to be a vexatious litigant, or in the alternative, a request for determination that her filings were frivolous, was in fact filed on Friday. Ms. Leyva has made the allegation that I participated in an ex parte communication with the court by virtue of filing this motion. Of course,
objection is not in filing the motion, it's in receiving an order for hearing, despite me not receiving any order for hearing, again, after the closing of courts. How is that possible if it's not ex parte communication?
Is the court, of course, aware, a motion is a request for relief. It is not an order by the court granting that relief.
No, the order was for a hearing, which again, I never received, which I was sent by Kate Daniels, who obviously received it through ex parte communication, which is against the law. And therefore, your hearing, this motion needs a continuance and should be heard at a further time after you have been able to, I have been able to respond appropriately, number one, and number two, prepare for it. And number three, I'm included in the communication from the courts, and there is no ex parte communication involved.
Your Honor, as the court is aware, I'm not required to marshal my evidence prior to the hearing. Presentation of evidence to support the relief I'm requesting is the purpose of us being here.
Ms. Borum, you're breaking up really bad on this end.
Oh, no.
So let's go ahead and start back where you were.
Here, am I coming through now?
You're coming through now.
Okay. I'm not sure where I broke up, so I'll just back up a little bit. As the court is of course aware, the motion that was filed was not an order. It was simply a request for relief, and I am not required to marshal my evidence within a motion. In fact, that's the purpose of us being here today, is to have said evidence presented to the court, with Ms. Leyva having the opportunity to respond to such evidence so that a determination can be made on the relief that I'm requesting. It was filed and set last Friday, meeting the requirements under the code that she have 3 days notice of the motions that were filed and set by me today.
Objection, I believe that, again, this requires a 3 business day notice. And because it was a 3-day Memorial Weekend, this is insufficient.
All right, Ms. Borum.
Your Honor, my motion was submitted. It was submitted on Friday. It was then, Ms. Leyva received a copy of it. It was properly filed. It was properly set for hearing to be heard today. And as the court is aware, there's—
Objection, it was again not properly set for hearing because the order was sent through ex parte communications, and I have again not been provided a copy of the order from the courts to this date.
She was provided a copy of the notice of hearing by my office. I believe Ms. Leyva might be a little confused what an ex
I
parte—
agree. So her office had interactions with the courts in a way that they were able to receive a court order after hours on a business day of a holiday weekend. They were able to receive this order without any communication with myself whatsoever, and this is considered appropriate by the courts.
None of that is true. None of that is true.
It is true, and I can pull up the emails right now. The times are stamped on every notice.
All right, Ms. Borum.
Would you like me to with attorney's fees?
Yes, go ahead.
My state bar number is 24040-229. I've been practicing family law in Tarrant County for a period exceeding 15 years. I'm familiar with reasonable and necessary attorney's fees filed, that are required in cases of this nature. Specifically, in the case before the court containing the 5 motions to strike filed by Ms. Leyva, in addition, having to review the approximate 40 filings that have been filed by Ms. Leyva since approximately July of 2020. So as Ms. Leyva references many of these issues within her motions that were set before the court, and also within multiple notices and motions and affidavits, which constitute hundreds of pages that she's filed with the court, having to review that and to defend my client in this current proceeding, that being limited only to Ms. Leyva's motions that have been filed before the court, I would represent that reasonable and necessary attorney's fees for this motion are approximately $4,000. I would ask that Ms. Leyva be ordered to pay $4,000 in attorney's fees directly to my firm on or before a date certain, given that there was quite a bit of preparation work that was required to respond specifically to her motions, and also the fact that the motions were filed, in my estimation, after the relief that she had requested had already been waived in the Rule 90 of the Texas Rules of Civil Procedure. And so for those reasons, I would request that the court deny her relief and award attorney's fees in the amount of $4,000 on her motions.
All right, any questions of Ms. Borum on her attorney's fees, Ms. Leyva?
No, but I would like to respond.
All right, you may.
Okay, first of all, I am representing myself because I cannot afford a lawyer. If Nick cannot afford a lawyer, he can also choose to pick up a book and figure out how to defend himself. Secondly, there is already been proven today in a court of law that they committed fraud upon the courts on multiple levels and have been deceptive and lying not only to you, Ms. Wells, but also to everyone involved. Now, all the additional filings were not filings for hearings. They were requests from the courts to rectify this issue. I was not attempting to bury her emotions. I was simply attempting to attack the criminal implications that have happened in this case by Ms. Newell and Nicholas Leyva, and now seem to be carried on by Ms. Borum. I was not intending for that to happen. It was to the court, specifically to the judge requesting relief, which has been in there since January of this year, which again has had no response. And I've had to wait 6 months for a hearing while my children have remained in Texas with no contact with their mother. Additionally, I have already submitted my affidavit of indigent. I don't have any money, cannot provide any money, and I have not signed a contract with Ms. Borum. I have not promised her any money. And if the court sanctioned this, they are again willingly assisting Ms. Borum and Ms. Newell and continuing to defraud the courts. And as a judge, I assume that's not your intention and that you don't want that to happen. You want to uphold the letter of the law. And I know there has been a lot of issues with this case and a lot of deception. And I hope that at this point that you can now see through that.
All right, the motions to strike are denied. The court finds that Mr. Leyva is entitled to attorney's fees in the amount of $2,500, which Ms. Leyva is ordered to pay to Mr. Leyva directly at his residence address by June 30th of 2021 at 4 p.m. That'll be the order of the court.
Okay, I'll see you guys in appeal. Have a nice day.
All right, wait a minute. We still have Ms. Borum's motions.
We're going to hear her motion, even though she put it in again on Friday on a holiday weekend after the courts, 1 minute before the courts closed, and I still have not received the order. Are we really going to move forward on a motion where I have not received any order from the courts for a hearing?
Well, Ms. Leyva, I was going to ask you, were you wanting a motion for continuance on that?
I did. I responded with a motion of continuance.
All right. I do think it's been a minimal amount of time for the allegations that have been made for notice. So I'm going to grant the continuance on that. Ms. Borum and Ms. Leyva, if you will, after this hearing, get with Ms. Lopez and get another hearing set on that motion, and I will grant her motion for continuance.
Thank you.
All right. Thank you, Your Honor.
Thank you.